If you heard that a March 2026 court ruling suddenly wiped out gun laws across the country, stop right there. That kind of headline gets people in trouble, fast. It gets people charged, disarmed, fined, dragged into court, and sitting in a room wondering how one clickbait video turned into a real criminal case. And that is the part almost nobody is prepared for. The danger is not just bad law, it is bad information. Because one court ruling can change something important without changing what most people think it changed. And if you act on the wrong version, the consequences land on you, not the person who posted the headline. Here is the truth that matters. A real March 2026 court ruling did shake up the gun law conversation, but it did not create a nationwide free-for-all. It did not erase every magazine limit, every carry restriction, every federal prohibition, or every state rule overnight. What it really did was reopen several pressure points in the law and expose how confused the legal map has become. That confusion is where people make expensive mistakes. They hear one ruling, assume it applies everywhere, and move like the risk is gone. It is not gone. In some places, the legal danger got smaller. In other places, it did not move at all. And in a few areas, the rules are still unsettled enough that one wrong assumption could cost you your rights before the courts ever finish sorting it out. The first big change people are talking about came out of Washington, D.C., when the local appeals court struck down the district's ban on magazines holding more than 10 rounds. That matters. It matters a lot. The court basically said those magazines are common enough that D.C. could not ban them outright under the Second Amendment. That was not a tiny technical adjustment. It was a direct hit to one of the most argued over restrictions in gun law. And for the person in that case, it triggered more than one reversal. The court also threw out connected convictions that depended on that now invalid ban. That is the part that made people sit up. But this is where people go wrong. They hear that decision and think every state magazine ban is dead. No, that is not how this works. A ruling in D.C. does not magically erase laws in California, New York, New Jersey, Illinois, or anywhere else. Different courts can disagree. Different states can keep enforcing their own laws until a higher court or a local court says otherwise. That means a person can watch a dramatic video at lunch, toss a 15-round magazine in the truck by dinner, cross a state line on Saturday, and suddenly be facing a legal problem they never saw coming. If you care about protecting your freedom instead of gambling with it, subscribe now, because the most dangerous part of this topic is not the law itself. It is the false confidence people walk away with. The second thing that changed is more subtle, and this is where it gets serious. In that D.C. case, the court did not just question the magazine rule. It also reversed related charges tied to the gun, the carry issue, and the ammunition because those charges were wrapped around the now unconstitutional ban. That sounds huge, and it is huge inside that case, but it is not a universal shield. It does not mean every gun charge connected to registration, licensing, or ammunition laws suddenly disappears everywhere. Courts look at how those charges connect to the specific facts and the specific laws in the specific place where the case happened. That is why legal headlines can be so dangerous. Two people can hear the same ruling, and one is safer while the other is walking straight into a trap. Picture an ordinary gun owner trying to do the right thing. He buys a firearm legally. He keeps it in the home. He thinks a recent ruling means the local paperwork rules around it are now pointless or unenforceable. Then a traffic stop happens, or a defensive gun use gets investigated, or a domestic call brings police to the house for something unrelated. Suddenly, the question is not what he believed. The question is what the law in that place still says on that day. That is what nobody tells you. Belief does not beat enforcement. A rumor does not beat a prosecutor. And confidence pulled from a viral thumbnail does not beat a judge reading the actual statute. The third area people are badly misunderstanding is the federal ban on gun possession by felons, including many nonviolent felons. In early March 2026, the Supreme Court declined to take at least one challenge involving that issue. That is not the same thing as striking the law down. It is not the same thing as restoring rights nationwide. It is not a secret signal that the rule is gone. It means the prohibition still stands unless and until something more direct changes in a way that applies to the person involved. This is a painful area because a lot of people want a simple answer. They want to hear that an old nonviolent conviction from years ago no longer matters. But for most people, that is not the safe assumption. And this is the heartbreaking part. Someone with an old fraud conviction, a paperwork crime, or a mistake from years back may honestly believe the courts are moving in their favor. They may even feel morally justified. They may tell themselves they just want a shotgun at home to protect their kids. But the law does not care how understandable that feeling is. If your rights have not been legally restored through the proper path, you are still stepping into danger. If this kind of practical, no-nonsense breakdown helps you cut through the noise, tap like on the video so more people see it before they make a mistake they cannot undo. The fourth issue is the one that could blindside more ordinary people than almost any other, and that is the federal rule involving unlawful drug users, especially marijuana users. This one is still unsettled at the Supreme Court level as of now. The justices heard arguments in March 2026 over whether the federal government can keep banning gun possession by people who are unlawful users of controlled substances. A lot of people heard about that case and instantly jumped to the most dangerous conclusion possible. They assumed the law was basically over. It is not over. A case being argued is not the same as a case being decided. And even if a future ruling narrows the law, that does not protect you today if you act like the risk has already disappeared. This is especially dangerous because marijuana law is a mess. In one state, it feels normal. There are stores, ads, medical cards, and a cultural message that says this is basically settled. But federally, the legal risk has not simply vanished. So imagine a person with a clean record, a concealed carry permit, a legal gun purchase, and occasional marijuana use. In his mind, he is just living like millions of other people. In the government's mind, depending on the facts and the law applied, he may still be standing inside a serious legal problem. That gap between what feels normal and what is still legally dangerous is exactly where people get hurt. And by the time they understand it, it is often too late. Keep watching, because the carry issue that comes next is the one that catches even careful gun owners off guard. The fifth area is carrying on private property that is open to the public, places like stores, restaurants, and other businesses. The Supreme Court is weighing a major case about whether states can default to no carry on private property unless the owner says yes. That issue matters because a lot of gun owners assume a permit means broad permission unless a business posts a clear sign saying no. But in some states, lawmakers flipped that idea around and tried to make the default rule the opposite. No permission unless the property owner explicitly allows it. That is not a small change. That can turn an ordinary walk into a store into a criminal issue, depending on the law where you are standing. And here is what most people miss. Even if the Supreme Court eventually trims those laws back, you still cannot act like the decision already came down in your favor. A permit is not a force field. It does not erase private property rights. It does not cancel every state carry rule. It does not protect you from a misunderstanding at the entrance to a business when police get called and the facts start getting sorted out later. Later is not when you want clarity. You want clarity before your name is in a report. If you know someone who carries and still thinks a permit means they can go almost anywhere, share this with them. That one misunderstanding can wreck an otherwise law-abiding person's life. The sixth area is broader carry restrictions in so-called sensitive places. This is where the legal map becomes a minefield. Some states have tried to ban carry in long lists of locations, from transit to parks to libraries to places that serve alcohol. Some of those rules have been blocked. Some have survived. Some are still being fought over. And this is where people get lulled into thinking the whole structure is collapsing because one court somewhere was skeptical of one category somewhere else. That is not enough. Unless a rule has actually been struck down where you live or where you are traveling, you should assume it can still be enforced. Not because that feels fair, but because that is the safer move until the courts say otherwise. Think about how ordinary this can look. A husband and wife drive across state lines for a weekend trip. One state feels permissive. The next state feels hostile. They stop for gas, grab food, walk through a public space, maybe step onto transit property without even thinking about it. Nothing about that day feels criminal. It feels normal. But normal is not the same as lawful. This is what nobody tells you. Most gun trouble does not start with a dramatic shootout. It starts with everyday movement through spaces people assumed were fine. If you want more content that helps you stay alert instead of overconfident, subscribe, because the next two issues are where homemade builds and common online myths start colliding with federal law. The seventh area is ghost guns and parts kits. A lot of people still speak as if federal regulation in that area got blown apart. It did not. The Supreme Court already upheld the federal rule that allows regulation of at least some weapon parts kits and unfinished components. In plain English, that means the idea that a parts kit is automatically invisible to federal law is a fantasy. People love the phrase ghost gun because it sounds mysterious and untouchable. In reality, it can become a very visible piece of evidence very quickly, especially if there is no serial number, unclear assembly history, or some other issue tied to how the firearm was made, sold, or possessed. The dangerous part is how many people still treat old internet advice like it is current law. Imagine somebody in a garage convinced they found a legal shortcut. No background check on that part, no record on that piece, no problem. Then something happens completely outside the gun itself. A traffic stop, a breakup, a theft report, a search connected to another investigation. Now that homemade build is not a hobby project, it is an object under a microscope. And once officials start asking when it was bought, what it was, how complete it was, what markings it has, and whether it falls under current federal rules, the person holding it may realize much too late that the legal ground shifted while they were still repeating old talking points from years ago. The eighth area is the one that ties everything together, and that is the huge category of laws that did not disappear just because the courts are still fighting about the Second Amendment. Assault weapon bans in some states are still being enforced. Age-based restrictions are still being challenged in different places. Serial number rules still matter. State transport rules still matter. Storage rules still matter. Permit rules still matter. Local definitions still matter. The mistake almost everyone makes is treating under challenge like already gone. Those are not the same thing. A law can be controversial, shaky, unpopular, and still fully enforceable today. That is the brutal reality. Courts move slower than people's confidence. This is why a viral headline can do more damage than an anti-gun lawmaker ever could. A bad law at least tells you where the line is. Bad information makes the line look like it vanished when it did not. And that creates the worst kind of risk, the kind you walk into smiling. If this breakdown has already cleared up confusion for you, hit like so it reaches somebody who is about to rely on the wrong headline and learn the hard way that internet certainty is not legal protection. So what should every gun owner actually do now? First, stop asking whether gun laws changed in some giant national sense and start asking a better question. Which law changed, where, and for whom? That question will save you, because the answer may be DC only. It may be federal only. It may be a pending case, not a final ruling. It may apply only to a narrow set of facts. And if you do not know those details, you do not know enough to act boldly. Second, separate three things in your mind. A hearing is not a ruling. A ruling is not always nationwide. And a legal argument online is not legal reality on the street. That simple mental filter can keep you from making a catastrophic mistake. Third, treat travel, carry, and possession like different issues, because they often are. A person may legally own a firearm in one place, illegally carry it in another, and unknowingly violate a magazine or location rule in a third. Fourth, if any issue in your life involves marijuana use, an old felony, a homemade build, altered markings, or a permit question, you are already in a higher risk category whether you like that fact or not. That does not mean panic. It means precision. It means checking the current law where you live and where you plan to go. It means not relying on a friend, a forum post, or a guy in a pickup at the range who says he is pretty sure the courts killed that rule last month. And the reason this matters so much is simple. Most people do not lose money and freedom because they were trying to be criminals. They lose it because they were trying to be normal. They were trying to protect the house, drive to work, visit family, keep a gun in the truck, build something in the garage, carry with a permit they thought covered more than it did. They made one ordinary decision on one ordinary day based on information that sounded confident but was not complete. Then the phone rings. A lawyer has to be called. The gun is seized. The case starts. The cost begins. And suddenly the person realizes the real danger was never just the law. It was misunderstanding the law while feeling completely sure. That is why the March 2026 ruling matters so much. Not because it erased everything, but because it exposed how unstable and confusing this whole area has become. One court says a common magazine cannot be banned that way. Another issue is still pending at the Supreme Court. Another challenge gets turned away. Another state keeps enforcing rules until somebody stops them. It is a patchwork, and patchwork law punishes lazy assumptions. That is the lesson. Not celebration, not panic, clarity. Because clarity is what keeps an ordinary citizen from becoming an example. So if you remember nothing else, remember this. Do not let a headline make legal decisions for you. Do not treat one court win as a nationwide permission slip. Do not assume a permit solves every carry question. Do not assume marijuana and gun ownership are automatically safe together just because culture changed faster than federal law. Do not assume a homemade build is invisible. Do not assume an old conviction no longer matters because somebody online said the courts are fixing it. And do not assume tomorrow's possible ruling protects today's behavior. That mindset is how people stay free, stay armed where lawful, and stay out of rooms they never wanted to be in. If this helped you feel sharper, safer, and more prepared, like the video, subscribe for more straight answers without the nonsense. And most importantly, share this with the one person in your life who follows gun headlines but never checks the fine print. Because ignoring bad information is smart. Passing it on is dangerous. And when the subject is your rights, your money, and your family's future, getting this wrong is a mistake you may not get a second chance to fix.